committee session of our Health and Human Services Committee and Public Safety Committee, and I have to believe that this in some way saves the county a little bit of money because I am on both committees. And have the honor of chairing this particular session, but obviously we'll be doing it hand in hand with my colleague and co-chair friend, Councilmember Sidney Katz. And of course, we are here to have a work session to discuss Bill 3520, Human Rights and Civil Liberties, Fair Criminal Record Screening Standards, and which was sponsored by my colleague and friend, Councilmember Will Jawando. In the audience, we have the great Jim Stowe, who will be here to speak on behalf of the executive branch, and also will ultimately, if this bill does move forward, have responsibility of oversight. And this particular session is being staffed by the one and only Christine Wellens. Thank you, Christine, for the great packet. And why don't we start by, if Councilmember Jawando, as the sponsor of this bill, if you could make some opening comments, we'd appreciate it.
Thank you, Mr. Chairman, and to all my colleagues, Council President and Public Safety Chair Katz, and Councilmember Rice and Hucker and Glass. Good to see everybody. And Ms. Wellens, thank you. And Mr. Stowe, I know I'll see you later. This bill is, as I explained when I introduced it, is building on some work that the council had already done back in 2014. I think that was the date. And when Councilmember Branson and I think Councilmember Rice and Navarro and others were co-sponsors to, undergird an important commitment we've made here in the county that when people make mistakes and that we should be about rehabilitation and getting people back to being productive members of society. And when we know, unfortunately, some people don't make any mistakes but still have a record for some reason. And that's an unfortunate occurrence as well. But that we want to make sure that all of our members of society can be productive, have an opportunity to use their skills, talents, and abilities to benefit themselves and their families, but also the greater society. And that's what this is about, to let people see the humanity, really, in people, in their skill set, and judge them based on their qualifications, not on some previous mistakes. Because Lord knows, if I was judged on my previous mistakes, I wouldn't be here, and many of us wouldn't be here. And I think that's the heart of the bill. The specifics are that it expands, just briefly, this to include more employers. The almost 85% of employers who have less than 15 employees in Montgomery County. We all often talk about our small businesses being the lifeblood of the county, and they are. But for various reasons, many of them are not covered in this by the current law, which is only covers employers of 15 or more. And then we also changed some of the standards to make certain low-level offenses or arrests or arrests that don't result in conviction and other things that I'm sure Ms. Wellens will explain, things that can never be asked about at any point. And then finally, we push the period out of when you can ask to, again, after the people have gotten a chance to get to know, and if there's a conditional offer made, which at that point, you like the person, you think they have the qualifications, you talk to them several times, most likely, then you can consider and ask about that information. So giving folks a better chance. There are several other states and localities that have done this, similar things, and I think being the progressive county we are, that we should take this step to give more and more of an opportunity. The last thing I'll say, Mr. Chairman, is I visited, before COVID, as part of my library tour, I visited the correction facility and spoke with a lot of the young men and women who are dealing with either being incarcerated or formerly incarcerated and trying to better their lives and get out and get a job. And the number one concern I heard was, I really need help getting a job. And obviously, I think this is one of the many things we can do. There was also an event that day to bring together employers, robust outreach and connection, and lifting up the positive benefits of this community is also something we're going to need to do. So I think there's more work than just this bill, but I think this is a critical component. and I hope we can move it forward. And I know, Mr. Stone, I keep giving you more work. We need to give you more money. I'll just say that as well. That's not on the topic today, but I acknowledge that. Thank you, Mr. Chairman.
Thank you, Councilmember Jawando. I'll note that Councilmember Jawando is joining us as a guest. He's not a member of either committee, but obviously he's very passionate about this issue, and we so appreciate his attendance. Chairman Katz, was there anything that you wanted to say as we get started?
No, I'm appreciative of everyone's interest, and you know, as a person that had a small business, you know, and there again, we need to talk about the number when we go through it, the number of employees that this would affect, the smallest employers. We heard from some of the people at the public hearing that they were concerned about the numbers of employees someone would be hiring or have had hired. But as a small business owner, I didn't have that many employees, but I hired many people that I knew had prior convictions, especially as a juvenile or other. I mean, you knew them, and you realized that they had made errors, and you gave them a second chance, and many times they were one of the finest employees that you had. So that second chance is good for both the employer and the employee, as long as people are careful and realize and are appreciative that a second chance means this is the chance to really prove yourself. So I appreciate the opportunity to work on this legislation.
Thank you, Mr. Chairman. So we will hear from Jim Stowe in a little bit, but first, Ms. Wellens, if you could establish context for us for this particular bill and then begin walking us through the packet. And I'll remind my colleagues, if any of you would like to speak, just text message me and I will add you to the list. Ms. Wellens.
Thank you, Chairman and members of the committees and Council Member Jawando as well. So Councilmember Jawando summarized the bill and identified.
Ms. Wellens, your feed is coming in and out. You're a little delayed. So I don't know if there's a way to tighten that up a little bit, but just to be aware.
Okay. All right. Is it continuing to do that when I speak directly into it?
No, that's better.
That is better. Okay. Because I was going to say my other options, I can call in my phone, and that might make it better. But so I apologize. I'll try to speak directly into the mic. So Councilmember Jawando explained the major features of the bill. In terms of summarizing the bill, I just wanted to add, to elaborate on the particular offenses or alleged offenses that an employer would not be able to consider at all under this bill. And those include, those include first convictions. So those include first convictions for trespass, disturbance of the peace, or assault in the second degree. It also includes convictions of misdemeanors that are if at least 3 years have passed since the date of the conviction and the date of any period of incarceration. And then, of course, any matter for which records are confidential in the juvenile justice system or criminal records that have been expunged. So those are the particular offenses that would not be considered by employers under this law. And that kind of segues into at least the first topic addressed in the staff memo, which is the inclusion of second-degree assault in the list of offenses that may not be considered. And I think, I'm sure that the sponsor could elaborate on this, but I think that second-degrry assault, the idea is that this is normally a misdemeanor, and it's often a misdemeanor that's disproportionately prosecuted against men of color. And so I think that is for the reason of the inclusion in the bill. The county attorney's office raised the point that there are certain second-degree assaults in Maryland that are actually considered felonies, in particular assaults of law enforcement officers, parole or probation agents, or first when the person committing the assault knows or has reason to know that the person they're assaulting is law enforcement or an EMT or probation agent. So I guess there are a couple of options for the committee's consideration related to this issue, which is, one option might be to remove second-degree assault from the list of offenses that can't be considered. One option might be to amend this provision about second-degree assault so that you would consider it only if it is a felony, only if it was a felony, but not if it was a misdemeanor. Or, of course, you could certainly leave the bill as is. So I'll pause to see if there are questions or, if you want to further discuss that issue.
Thank you. And I should have noted at the beginning, there's definitely a possibility this will make its way through both committees today and to a vote. But if there are follow-up items, obviously, as we do on any issue, reserve the right to come back if there's more due diligence that needs to be done prior to voting. So just leave that possibility open. Councilmember Jawando, did you want to add more context or background on this specific item?
Sure, just briefly. I think we don't have a like a third degree assault, so the OCA opinion is right, is that they're second degree assault, while many times more minor. A lot of people that get into a fight or something or hit somebody, that is considered that. So I think, again, this is after 3 years, or Ms. Mullins can say it's after 3 years, correct, Ms. Mullins? I want to make sure that's that would fall into this. This is not one of the ones you can never ask about. This is after 3 years have passed, correct?
Okay, this is part of the bill where you could never ask about it, but only if it's a first conviction. So
right.
If you had multiple convictions, you could ask about that.
Right. So if it was a first conviction, you had this, which could be a fight or something, and it was first conviction, you couldn't ask about it. But if it was something that had multiple times, was a pattern, you could ask. I know Ms. Wellens made a possible that you could limit it to first degree, or I think misdemeanor assault, second assault. But obviously I drafted the bill the way it is because I think that's preferable, and I think it strikes a good balance with it just being the first conviction.
I think it is an important point that, there's some second degree assaults that do rise to a higher level. So I guess some of this, Mr. Stowe, if you could step in here, obviously capacity, both of your incredible office, but also of the employers to be able to track information such as this and parse out that kind of an important nuance. Do you have any thoughts on this particular component, Mr. Stowe, or what is your feeling on this particular part of the measure?
First of all, good morning to all of you. I should say good afternoon to all of you. The one thing, I guess, from my perspective, it just sort of jumps out as a possible issue for employers, vis-a-vis through just the idea of it being an assault kind of attached to it. When you obviously dig down into it, as Councilman Jawando has said, you see that there is a broad sort of definition therein. But I think on its face, it creates a bit of a challenge when people read it. As far as enforcing it is concerned, we're going to find ourselves having to dig into records anyway if we get a complaint from someone who was applying for a position that was turned down. And so it would just be another element of our analysis. So I don't see that as an issue necessarily. But on the other hand, the first comment I made, I think may at least be for your consideration, a way to get at the same thing, just at the same time, maybe having a different way of approaching it in terms of language. Just a suggestion.
I appreciate that. I think having a compromise that looks like keeping to the spirit of the bill, but acknowledging that there are some of these offenses that do rise to a higher level that I think a reasonable person could agree would raise concerns. And so I do think having that nuance, as Ms. Wellens mentioned, would be warranted here. But I'd love to defer to my colleagues on the committee to get your thoughts on this specific item. Looks like Councilmember Rice may have a question, thought, or point.
Yeah, no. So I'm thinking the same thing, and these were all things that we struggled with back in 2014, trying to figure out what the right nuanced approach was in terms of what crimes we thought were rose to the level of, and it's difficult because it's all situational, right? And so every single one of them is going to be one that could be one thing or the other. And so I think erring on the side of giving a little bit of leeway towards being more of the minor crimes, makes more sense from my standpoint. So having the misdemeanor, second degree, to me would make more sense in terms of and I don't even want to say compromise, because compromise isn't the right word.
Yeah.
What it is it's really one in which understanding, just as Councilmember Juando said, and I couldn't agree with him more. Look, this is about people making mistakes, but we also need to judge the severity of those mistakes and the impacts that they have on people in our community as well, and the potential for what that might mean in terms of propensity as well. And it's not to say that persons should be judged by one mistake, because I agree with Councilmember Juando. I was judged on the multitude of mistakes I've made in my life, as we all have. We are not perfect, and I never want to portray myself to be. Then a lot of us wouldn't be where we are today. But that being said, when it comes to some of these assaults, it is important to try and figure out where that right sort of comfortability is. And so for me, I would err on the side of misdemeanor, secondary degree assault, which is what Ms. Wellens had recommended. So just wanted to put that thought out there.
Thank you. Chairman Katz?
Thank you. I guess I'm off mute. I agree with that. I think misdemeanor assault is the right way to go. But then I'd like to know, if a person is applying to become a police officer, how does this fit into that scenario?
In response to that question, the police department is specifically excluded from this law, so they would not be affected. Also, employers that are employing people who work with children or vulnerable adults also are not affected by this bill. They're exempted. And then also the fire rescue service is exempted.
Can we put that in as part of the definition of employer, so that there's no question?
Well, there's definitely no question, because I can include in the bill the section of the existing law that I didn't include, which has those explicit exemptions. So I guess I would suggest, I don't think that we need to change the definition of employer for that, because under the existing law, it's already clear that they're exempt. But I could include within the bill the relevant exemption so that it's clear to the reader, that those types of employers aren't subject to the bill.
I think that would be helpful. I do, so that there is no question what we're discussing. Thanks.
Okay. Councilmember Juando, you had another point?
I did. I just wanted to be, I wasn't as clear as I wanted to be the first time around. And Ms. Wellens, you can correct me if I'm wrong, but my understanding is that assault in the second degree in Maryland code is a misdemeanor by definition. Is that correct?
You're correct, except the only exception is for the one that the county attorney's office identified for assaulting law enforcement or, emergency personnel or parole agents.
Right. And so, yeah, correct. And so the suggestion, and then I'll ask another question. I just want to make sure my colleagues, the reason why, and I appreciate that, tough calls but the reason why I think it's important to not include a first offense of second degree assault, again, to the point of propensity, I think by saying the first offense is not included, Because if you under current law, if you get angry and swing at somebody and you miss, even if you don't hit them, because the second degree assault definition only requires that you attempt to cause physical harm. It doesn't even require that you cause the harm. And so you would have situations where that could be found to be second degree assault. And again, we're talking about the first offense. I just think that the limiting factor here, obviously the police and law enforcement being excluded, as was said, but I just think the limiting factor is that it's only the first offense. And if you had multiple, 2 or more, then it could be asked about. I just think there's a lot of people, again, myself included, for whom that could be a challenge, and we don't want it. I think it would go against the intent of the bill.
So I guess, Ms. Wellens, if there's a way we can, acknowledging that it is primarily a misdemeanor offense to begin with, except for a limited number of circumstances, but if we could acknowledge those limited number of circumstances in the language, I think that would be appropriate, just to put together any concern that an employer may have if it does rise to that higher criminal level.
I'd be fine with that. Thank you.
And I think this should be noted. This is for the discussion for when someone, initially applies. This isn't saying that they wouldn't hire you necessarily, but this is saying, in some cases, if somebody comes in and says, look, I want you to know I'm not an angel. I have had this problem, and it's been 5 years ago, never had a problem since, but this is what happened. All of a sudden, most people say, I really appreciate them telling me, so therefore, you're already through the part of that system where you'd hire them at the end. Some cases they say, well, I didn't know that one, and all of a sudden it becomes a surprise. So it's a question of when do you know in order to feel comfortable with that person working with you.
So, Ms. Wellens, is that clear? Does that make sense in terms of a follow-up? Is addressing that in the language?
Yeah, so kind of explicitly folding in the scenarios of when it is a felony under the state law, namely when law enforcement or those other categories are included. So instead of just a cross-reference to the state law, kind of articulating the circumstances so it's more clear to the employer.
That seems reasonable. Okay, seeing heads nod, so let's move on to Councilmember Harker. Did you have a point?
I don't even have a point. I might have a question just out of curiosity since we're on the topic. Ms. Wellens, I'm not so familiar with the definition, but it's been my impression, I thought that second-degree assault, the misdemeanor, right, was sort of the default charge you get if 2 people get in a fight, like in a restaurant or a bar or something, and there's really not witnesses, the police get called. I say he did it, he started it, he says I started it. We both might get charged with second-degree assault, right? And it's not necessarily the thing that would make me a terrible employee for the restaurant. It's a pretty commonplace charge in a situation like that, right?
Right, and I think that's why it was it was included in the bill to begin with. Yeah, I mean, if it is worth noting if you have if you are attempting to cause serious bodily injury, or you do cause serious bodily injury, you've committed a first-degree assault.
Right.
If you're any type of assault with a firearm, that's first degree. That's not going to fall into the second degree category.
For anybody that even fights back, they might get charged with second-degree assault. Has been my impression, right? Yep.
Yeah, I mean, you could get into a fist fight and you're charged with second-degree assault. Right. I mean,
the officer just gives both parties, right? Okay. Anyway, thank you, Mr. Chair.
I think that's a point, and I'm going to call on you in 1 second, Chairman Katz. I think that's an important point, Councilmember Harker. I do think, though, to Mr. Stowe's point earlier, people are just going to see assault. The first versus the second degree is not what they're going to focus on necessarily. And I've learned a lot just in this work session and through this process and in reading the packet that I didn't know before. So I do think providing some provision for that distinction, if and when somebody raises that concern, if it does go to that level, still makes sense, but it's a point well taken. Chairman Katz.
Thank you. I just wanted to point out that in many cases, domestic violence assaults are considered second-degree assaults. So we certainly don't want, we want to be very, very cognizant of domestic violence concerns. And there again, I think it's noted. It should be noted that I think if we do it this way, then with misdemeanor assault, then I think that would help clear up the situation.
I do want to pull that string a little bit. That is an important distinction. I had the same thought, and I just want to be absolutely sure that that's addressed or covered, because it's an important point. And
wasn't that what you had asked, Mr. Chair? Wasn't that what you had asked Ms. Wellens to kind of identify some of those kinds of things in the list? Because that would also be something that would be,
So Ms. Wellens, just to be clear, if you can include that particular provision as well, with regards to domestic violence situations, I think that is important and relevant.
I just point of clarification. What are we including? Are you saying that domestic violence assault, you're distinguishing that from other types of second-degree assault? Is that what you just?
Actually, I'd like to know is it even possible to make that distinction? I guess just to take a step backwards, how is it characterized when somebody is convicted of second-degree assault? Is that something an employer could even identify or look up, or is it under a umbrella of, description?
I think that might be the difficulty, is that, as President Katz said, there are going to be domestic violence cases that fall under the umbrella of second-degree assault. But without looking at the underlying facts of the case, I'm not sure how the employer would be able to figure that out. I can look into it further, but I just don't. I think that would be a challenge. Unless they can get, the underlying court records. I don't know. Another possible way of delineating it is, maybe, asking the applicant, do you have, whether you have a protective order that has been entered against you, might be a potential way to get at domestic violence issues. Sorry, that's not a totally complete answer. I'm not sure that it will be easy for them to tell.
I see, Mr. Stowe, it looked like you may be wanting to say something.
Well, a couple of things. One is that kind of inquiry would not happen until that conditional offer is on the table, that according to what this law is proposing, that an employer might even do the background check and might even unveil the criminal record, as it were. And my concern would be, and I'm giving you benefit of what we hear by way of the employers when we actually are now going out, and employees for that matter as well. But more employers who are saying, I want to sort of comply with this, but these are just more obstacles for my trying to be one that may look to hire some person that's been incarcerated, as an example. And so I'm just trying to think in terms of how I can make this work, how we can, in fact, have what I think Councilmember Jawando was after. Just to say, as an aside, real quickly, that I was on the panel at that same event that he's talked about at Clarksburg Jail, and I heard the same thing that he suggested that he heard as well. And one of the issues is about perception. Perception that that person who now has been incarcerated, now trying to get himself or herself back into the workforce, goes already into that interview process with a strike against them and possibly prejudices on behalf of whomever's actually doing the interview. And the more we can do to resolve those issues, or at least delay those issues, so that he or she gets a chance to explain themselves, to be able to just state their case, and then be clearly heard without there being some preconceived notion that, this is nothing more than an exercise, but to really be considered seriously for the opportunity is what they really were talking about that particular day we were at Clarksburg's jail. That's what they want. And they're ready, prepared to go into the workforce. They just want a fair opportunity to be evaluated in a way. So I'm just suggesting that as you think this through, that we try to remove any roadblocks that might prevent that from being a fair exchange and a fair assessment of his or her talents. Because at this point in time, they're almost there. They've got a conditional offer on the table. They're now doing the interview process vis-a-vis through the background check, etc. And they're just about at that time they can say, I got this job. And so I would hope then that whatever we put in here, and of course we'll enforce whatever you in fact pass. But the idea is that whatever happens at that point, I would hope that the language does not somehow or another create yet another hurdle for that person when they almost got that job. My thought.
Mr. Hucker, followed by Mr. Katz.
I just want to support, I think, the spirit of what Mr. Stowe is saying. I'll just say, as a matter of context, I'm enthusiastic about this bill. I'm grateful to Councilmember Jawando for putting it in. I wasn't on the council when it was passed, but I was, I think, still serving in Annapolis. I remember coming to Rockville, frustrated that the bill hadn't passed at the state level, and grateful that Councilmember Elrich had put it in and going to the launch event, because I believe that it was the right thing to do for the county, and that passage at the county level would help us get it passed at the state level. I mean, it's really all about second chances. But just to be clear for the 2 or 3 people watching at home, this bill doesn't require any employer to hire any employee. Right. It just makes people conduct their due diligence in a sequence where they do the interview, they consider somebody's credentials and potential as an employee before they do this background check and rule them out on those grounds. Any individual employer is free to decline to hire any individual employee based on what they find later. And so I don't think we, the 6 or 7 of us should, 5 or 6 of us should get too far down the road at like distinguishing between different types of of second degree misdemeanors, when really this is about just giving people a second chance. It still leaves all the employer is still holding all the cards in this exchange. We're just sort of setting it up so people have an ability to get a second chance.
Chairman Katz, followed by Councilmember Glass.
Yeah, and mine's very quickly. I agree with that. To Mr. Stowe's point, it's going to be a secondary question. So I'm in agreement that this means that someone gets the opportunity to prove that they can do the job. Once the employer looks into it, and they're going to look at everybody else. It's not just, they might be looking at 3 different people, and this person for other reasons wouldn't get this job, but at least it gives them the opportunity to have a chance to get this job. And I think this is good, a good way to do it.
Councilmember Glass.
Yeah, good conversation, and the questions that everybody is asking, I think at the heart of what we're talking about, and has just been articulated by Mr. Stowe so well, is that the questions we have are questions that the employer can ask after having that interview or during that interview, and we're just providing the opportunity for people to fairly apply without any preconceived notions or discrimination against a single act that person might have committed. And so the questions we're all asking are good. I would suspect a good hiring manager or employer would ask the same questions at the actual interview, but this would allow them to get to the interview, and I think that's the goal here. So thank you, Mr. Jawando, for introducing this, and I think we're moving in the right direction to give people a second chance. So thank you. I yield back.
Chairman Katz.
Yeah, candidly, this one, I would think that the conversation we're having is on the application. I mean, it's not even the interview at that point. It's somebody that the application itself would have on there this variety of questions. And candidly, I would think, Mr. Stowe, if it would be possible, that Montgomery County, once we finally figure out what this is actually going to say, Montgomery County would offer an employer a prototype application, what they can and can't say, and then there is no question they are comfortable knowing that they're following the law until they actually get to an interview. I think that would be a good step in the right direction.
Yeah. And
Mr. President, if I may, let's remember now, what you did back in 2014 was to eliminate that question, period. So that applicant ought to go into that interview like any other applicant.
Right.
Because that question, whether or not they have a criminal record, is not there, or whether it should not be there on any application in Montgomery County, period. And so he should come to that interview just like any other applicant. And the kind of things we really are talking about, like you just said, are really secondary kinds of questions. Now, the thing that you did, and with Councilmember Joando's leadership here, is that we couldn't get there, as I recall. We couldn't get to where you all are today back in 2014. We couldn't, as my understanding, we couldn't make the case that we could do this upon a actual offer in the making. The best we could do is what we were able to do at that point in time. Now, all the other entities that I'm aware of, City of Philadelphia probably has the oldest program. They a long time ago had on a contingent offer or conditional offer, but we couldn't get there. And so, what my understanding is that where we are now today with this bill that has been proposed by Councilmember Joando is we're getting there. We're getting to a place that actually we're catching up to everybody else. To be honest with you. So we're saying then that yes, I'm coming to that interview like anybody else. My credentials are being in fact evaluated based upon what I'm presenting about the job itself. And before, you recall, they could ask questions at the end of the interview. But that now changed. Now it's got to be a conditional offer on the table before, again, the background check can be made, and then subsequent questions can be asked at that point in time, is my understanding.
yeah,
So a much better situation right now than before. And so if it works well, he or she should only have these issues that we're dealing with now when those secondary questions come up in that second interview or a follow-up phone call or what have you. Oh, by the way, I found in your record this. And then maybe there's other things at that point in time might apply. And the only other issue we've got here is that if, in fact, the complaints we get were suggesting that if a person believes in that their non-hire was a direct result of that record, then that employer must be able then to be able to say it, I should say, in a way that would suggest that there was no bias whatsoever based on that record, that the non-hire actually took place. And so that the employer is not off the hook in terms of just simply saying no, particularly if there's a complaint that comes to our office based on the law, as I understand it. They've got to be able to explain that that decision was made on something other than the actual occurrence of a record or a incident on that record. Is that clear what I'm trying to say?
Yeah.
It is. Thank you, Mr. Still. Councilmember Joando, followed by Councilmember Rice.
Yeah, just briefly, I just wanted to, and I think Director Still cleared it up. We were saying the interview. This is just you could ask after a conditional offer is being made, not an interview. And so, to his point, the application shouldn't have anything on it. People should be able to have that interview and then impress or not impress, and then have the follow up. And then once you get to the point of we're ready to hire, that's when that could happen. And so I just wanted to make sure that was clear, and I appreciate Councilmember Glass and Hucker and everybody's comments. Thank you.
Councilmember Glass. Councilmember Rice.
Thank you very much. So I just want to be sure we don't need to amend anything when it comes to 1, because I know that was the other piece of it. So I just want to get where we are at this point. So we had already said that we were going to seek clarifying language. I think we're now clear that we don't need to have that clarifying language. But the fact of the 1 or the first, is that already in the language? Does it say first, Ms. Wellens or Mr. Joando?
First degree assault?
No. The first offense.
Go ahead, Ms. Wellens. But yes, you can answer. Yeah.
Sorry. Yes. The information that you can't consider first conviction
Right.
of specified.
Okay, so that's already in.
Is in the language currently.
Beautiful. All right. Thank you.
are we enumerating? But we are enumerating. You are. I'm not on the committee, but I think you're enumerating the police and fire. I mean, I think that was. It's already covered.
Yes.
But I think just enumerating it for employers when they read the plain language of the law.
That's right. That's right. Yes. That was my understanding as well of reading the packet. So.
Correct. Chairman Katz?
Are we saying that an application is not considered an interview, that it has to be an oral interview?
Well, the interview is under this law is going to be not irrelevant, but the current law is that you couldn't ask until the conclusion of the first interview. What this would do was change that until you can't ask until a conditional offer is made. So I understand
that distinction. But are we saying that an application is not considered even, to me, an application is an interview. I mean, I understand it's not an oral interview, but it's getting the background information for somebody that's applying for a job. You're finding out their qualifications. So are we saying that an interview has to be an oral interview and that an application is different than that?
No, I don't think we're speaking, Ms. Wellens can say, but the bill as written doesn't speak to a distinction, doesn't define what an interview is. It just says you cannot ask about these types of criminal histories at all or until, depending on the offense, a conditional offer has been made, regardless of how the interview process goes and whether that includes Zoom or phone or application or anything else.
Correct. I mean, in theory, I suppose you could have
maybe take off your
purely.
Video.
Okay, I'm sorry. Is that any better?
Yeah, it's better.
Okay, sorry. So, right. So you, in theory, could. Under the law as amended, under the bill, you could not even have an interview. I mean, you could have some alternate type of process of, this might not be realistic at all, but, just a paper application and say, you look great, I'm going to hire you, I'm giving you a conditional offer pending background check. But then, yes, under the current law is when you're not allowed to inquire until the completion of a first interview. So that does kind of say, again, this would be the current law, but it does kind of suggest that if you want to ask about criminal background, then you have to at least conduct some type of interview first.
Okay, so to review really quickly, I think then what we're saying is on point number 1, we're going to go with the staff recommendation, which is basically that felony convictions of second-degree assault could be considered, and those felonies as defined include potential assault of police officers, fire and rescue, etc. So I think we'll move forward with that particular recommendation. And what is a follow-up, would like to find out a little bit more information about second-degree assaults. I appreciate the background and context that was provided in the packet, and I'm comfortable with moving this recommendation forward. But before going to full council, I would just like to get a little bit more information, Ms. Rollins, just me personally, on second-degree assaults in Montgomery County. Okay.
Absolutely.
Okay, now we move on to number 2. Ms. Wellens?
Sorry, I'm having trouble using multiple devices here. So the issue number 2 relates to the size of the employer. So as you know, under the current law, employers are subject to the ban-the-box rules if they have 15 or more employees. And then under the bill as proposed, any employer with 1 or more employee would be subject to the requirements of the bill. I included within your packet a chart. It's on page 4 of the memorandum, kind of setting forth the threshold numbers in various jurisdictions, various states, and some localities. Just within Maryland, the state ban-the-box law, like the current Montgomery County law, looks to 15 or more employees. But then, for example, in Baltimore City, there's more employers are covered. Their ban-the-box law looks at 10 or more employees. Prince George's County has a higher threshold of 25 or more employees. And then there are a number of jurisdictions, increasingly throughout the country. There are several that's, anything above 0. If you have even a part-time employee, that you're subject to the ban-the-box rules. And then I also just noted that for purposes of our minimum wage law in the county, employers defined as having one or more employee. So, and then as you'll recall in the public testimony, some representatives of employers, noted the concern of, that this is more, that the ban-the-box requirements are comparatively more onerous on the small employer who doesn't have, an HR staff necessarily, and that, and there are costs associated with complying with the law. So, and then on the other hand, as Councilmember Jawando noted, we have a lot of small businesses in the county, and, we want people to be able to have a fair chance at applying to those businesses. I'll stop there. Thank you.
Thank you, Ms. Mullins. Mr. Stowe, I'd like to start with you on this one. What are your thoughts, reactions, again, having had the opportunity to speak to employers on a variety of other issues, on that concern of organizations that may not have an HR department or the same capacity to conduct the same level of due diligence as maybe a larger company or corporation?
Mr. Chairman, that has been an ongoing issue for many employers for a number of the new bills that have been passed and entered into law in Montgomery County. So many of them may have a consortium that does all their personnel-related activity to include payroll and those kinds of things. There are some that double duty, meaning that they do it themselves. But the one thing they've asked for consistently has been just clarity. What is it that you want me to do? And how is it that I can comply? And is there a direction as to what it means? Is there some sort of guidance as to how I go about doing this? I mean, those are some of the key points we keep hearing over and over again. So I think what this does is, and we need to be just as clear as we can, and I'll try to be clear myself here, but to be clear as we can on what this really is talking about, because in most instances, persons who do background checks will do them anyway. So we're not adding any additional burden in that regard. As we said early on, the application will look the same as all other applications look. So they won't know who they're interviewing at that point, that he or she has a record or not. It's not until they're ready to hire that those kind of things sort of take shape and take form. At that point, then, again, if they already do background checks, they're doing a background check on that person as they would anyway. Any subsequent sort of dealing with that potential employee would be in terms of anyway, if they're going to hire somebody as a significant burden. From what I have learned and heard, I don't speak for businesses by any means or employers by any means, but I was suggesting that at least what we have heard would indicate that this would not be a particular add-on to what they're already going to do anyway if they're going to hire a person. Obviously, I would just share with you that the experience also has been that some of our smaller employers are more willing in some instances, and this is knowing who the person is and knowing him or her has a record, right, and taking that person on, and in many instances become a mentor to him or her. And so you certainly want to have a partnership in all that we do and say as far as this is concerned, but going in the door, nobody will know who he or she is in terms of whether they've got a record or not, and that way they can be evaluated fairly on their credentials and their ability to do a job, and then whatever comes after will be an activity that any employer who is entering into them anyway will have to do. So that would be my thoughts.
Thank you, Mr. Stowe. That's really helpful. Ms. Mullins, just a couple of questions, and I appreciate you putting up the chart that shows other states and jurisdictions. And actually, to anybody associated with the initial bill, was there a specific definition as to why we selected 15 at the time, or are there definitions within the other states that may differ in the number and size and scope, or is there any enhanced or reason beyond the number that has been articulated?
From what I can gather, based on reviewing the files from 2014, it appeared that the council, and maybe somebody who was here, at the time, correct me if I'm wrong, but it appears as if they looked at other jurisdictions, and there was kind of a range, and 15 seemed to be kind of towards the middle of the range. And at that time, there weren't jurisdictions that had anything more than, that had the 1 employee or greater than 0 employees. That has been more of a recent trend. And so in 2014, based on what I can tell, it looks like the council concluded that, 15 was kind of a reasonable number that was sort of in the middle of the pack in terms of what other jurisdictions were doing. I don't know if Mr. Stowe, Director Stowe, was probably here, maybe. I don't know.
And Councilmember Rice, I think, probably has a thing or two to add to this one, too. That's why continuity is important, folks. First Mr. Stowe, then Mr. Rice.
Okay. As I recall, it was a discussion in a work session very much like this, that this went back and forth, and Council, as I recall, and of course Councilman Rice can certainly clear this up, but did try to work with the sentiment that was both in the room as expressed by those who were present, and various input they'd already gotten prior to the work session, and for those of us who were able then to add to that, came up with what they felt was fair, because at that point in time we were talking about the interview. So that's what the difference is. We were talking about everything occurring in that law in 2014 relative to the interview process. And so we had people talk about that being a lengthening process, more involved in that process, and thereby providing additional burdens for employers at that point, particularly small employers. So I do believe, as I recall, that was part of the discussion. But what you're doing by virtue of this law, as I just mentioned, is that you do not do all those things relative to the interview, because it won't be like anything else. Let me change it around a bit. It will be different than a regular interview process they would have with any other potential applicant. And so therefore, those things that were issues then, I don't see then that there'll be issues today. Now, the other thing, too, I'll share with you very briefly is this. Most of those numbers, I can speak certainly to ours here, is in line with all of the other laws that we govern in terms of explaining or defining the word employer. So that definition now lines up with its application to every other human rights law we have on the books currently today in our county. I know the same has occurred in the state of Philadelphia, and I keep pointing them out because they, again, were so far ahead of everybody else in putting this in place in their jurisdiction. And the state of Maryland, again, I'm a little fuzzy there, but I believe also in terms of how they look at their law, in terms of violation of their civil rights laws, I think it also is 15 or more employees. And again, I'm a little fuzzy on that one. So, but anyway, the point I'm making simply is this, is that in our case, it does align with our definition for all of the laws and human rights.
Thank you, Mr. Stowe. Councilmember Rice, followed by Councilmember Giwando.
Yeah, so Director Stowe, thank you very much. And your memory is like a steel trap, sir. That's exactly what the conversation was. And keep in mind, we weren't as stood up as we are now when it comes to a lot of our laws that have come about. When it comes to discrimination in the workplace, all those kinds of things, we did a lot of work between 2014 and to get us where we are today. And the process is different. The burden, we were talking about what the burdens would be on small businesses who don't have HR directors and folks like that. And that's what the conversation was. If I don't have an HR director who's supposed to handle all this and understand it, how is the mom and pop shop going to make this work and understand what the rules are, right? That was the discussion. So yes, now it doesn't apply, right? Because it's a different scenario. And so to Council President Katz, concerns. I do think that it just will be important for us as we move forward with this to make sure that we're just educating our folks about what the process is going to be, because it is going to be a little bit different, right? But in terms of it actually being a challenge now, I agree that it actually won't be, because you're talking about an entirely different sort of scenario. And so because of that, you'll certainly have those burdens not there as obstacles any longer for some of the smaller businesses that don't have HR departments, people who handle this sort of thing, who can flush this stuff out. So I do agree that now that that's not an issue, the number really isn't that big of a deal. And so wherever we land, I think is fine, because we're talking about a very different process from where we were in 2014.
Thank you. Councilmember Giwando?
Thank you. So I would agree. I think we're heading in the right direction. I'm sorry. Just looking at this Breonna Taylor news, it's just devastating to me.
I didn't see it, but
they didn't. There were no charges for her death. There were charges that the officer shot too many bullets in the surrounding area, but nothing related to her. So, So anyway, the idea, I think, to Mr. Stowe's point, we want to have one, clear definition for all of our civil rights laws about how we define employer. I think that is very compelling for consistency here in Montgomery County. And, we shouldn't have a different bar. I think Councilmember Rice's point about the burden being very different, because now this law has been in effect for 6 years, and you shouldn't, be asking that question on an application anyway. And so I think this is, again, and if you don't have an application, you just physically can't ask the question until a conditional offer is made. So there's really no administrative burden in that regard. And so I think we should be consistent. And again, realizing that almost 85% of our businesses have less than 15 people, I think we want to make sure it's one and more. That's why I just want to give you the rationale, which it sounds like people are agreeing with. Thank you.
The consistency is the most compelling one for me, for sure, personally. But it does raise a point, and it's a point we bring up whenever we introduce very progressive and important pieces of legislation like this, and that is education and capacity. For this one in particular, given that, as you said, Councilmember Giwando, now 85% of businesses will now be included in this particular provision, I think that education is critical. And so, Director Stowe, I know that you're always trying to make $1 out of 15 cents, but I do have questions, and this goes to you as well, Ms. Wellens, in terms of implementation, grace period. What is the precedent? What is envisioned, Mr. Stowe, assuming we move forward out of committees today, assuming we move forward with this before full council, before the end of October, and then vote on this, what would be reasonable in terms of implementation to give businesses the appropriate runway to to give your team the opportunity to educate them on these issues?
Well, first and foremost, I should tell you that the city of Seattle had $100,000 for their campaign. So, to give an example of what some people are doing, and as a result of that, they get a number of positive results. That is to say, also from employers as well as from those who could be potential complainants, because now everybody knew the law. What we got to do here is we've been having some conversations with our Department of Corrections and Rehabilitation and trying to kind of figure out a campaign that we could put together that might be focused on education, both to employer and to employees. Of course, as you know, with the program already in place at our Department of Corrections and Rehabilitation, and dealing with folks returning to the workplace, they're having a great deal of success, and they've identified, as I understand, quite a few employers who are already on board. And so what they are already in process of doing is their folks are going out prepared to meet that world out there that without the help and assistance of the support of the department because they've had some prerequisite training. It is those who have not had that training that are going to run into a real problem. And so we've got to find a way to get to them. Your specific question, I have, deals with how we're going to do it. And that means then that we've got to put together a campaign, and now that this goes forward, we've got to do something anyway because this is going to be different than what's already out there. And so I've got to think this through a little bit. It's going to take me working with our public information officer that works with us as well, and our department, Angela and her group as well, working with those folks and trying to get that done. But the idea is that if we can come up with that program, that begins to be the first leg of what we have to do. The second thing that we constantly have an issue with in the current bill is to have those folks come forward who have a complaint. Again, it is such a difficult thing for folks to kind of get out there and run into the roadblock of not being able to be hired and be found out eventually. And that's what happens, by the way, to some that we are hearing from. They have, in fact, gone on board. They have, in fact, not put that down on the application as they should not be doing, only to find out later on that the background check was done, and boom, there you are. And they oftentimes make the phone call to find out, well, here's what happened, but don't follow up with the actual complaint itself. And so it's the second thing we got to be able to do. How do we reach that population? And the only way we can really do that, again, is work with the department and figure out ways we can at least get to those who are in the system about this new law, educate those folks, and begin the process of figuring out how we then get to the next tier of individuals who may not come through our system. That's going to be an ongoing process of figuring out how we do that. Today, I can't tell you that. But what I can tell you is that we can at least work with the population that we know exists and having them understand what's going on. Part of my being at the program back earlier that Councilmember Jawanda talked about was to say just what I'm saying now. And at that point, I was talking about the bill passed in 2014. So another session like that, I'm going to recommend be something we do as well, so we at least get to the current population in our jails. And then the third thing I think has got to be critically important is that we, move to a place where we really are talking about these opportunities for persons having this second chance being part of our core value as a community that is out there for persons. And so employers then can come on board and say to themselves that once we in fact find out that he or she is in a situation, we are going to give him or her then another opportunity then to be made whole again in their communities. And so those are three ideas I have right now. Again, gentlemen always come back to resources again in terms of how to move beyond that. But it is what it is, and we do the best we can what we've got to work with. But what I've said thus far are things that we can do. We can do them much better with more resources, but we at least can do what I just stated in those 3 points.
I think, given the sensitive nature of this topic, and I totally agree with the premise of this bill, it's the right thing to do, but we want to set it up for success right out of the gates, and like any bill, but particularly as it relates, when we're talking about workforce development in the environment that we're in now, with so many people being laid off, it's even more important for us to get this right. And so I do think, Ms. Wellens, as we do continue to move through the committee process, I think some consideration given to ensuring that the appropriate resources are in place to put the Office of Human Rights in the best position to succeed on all of these measures, but in particular this one I think is going to be important. And that could affect the timing of the implementation of this, because I think we need to do it as soon as possible, but it can't be an unfunded mandate. It just can't. Or we're going to create, especially in the short term, a number of problems that could have been avoided. So I think that's important. And also taking the lessons learned from 2014 and the initiative that was done then and applying them this time around, I think is going to be important.
Can I make one comment? If
Yes.
someone's in front of me, you can please.
No, you're up next.
Just briefly, I appreciate Director Stowe. As I said at the beginning, I think this bill will actually provide us an opportunity, I think, to kind of relaunch the program and the importance of it at a time when it's critically important, like you were mentioning, Mr. Albornoz, about trying to get folks back on their feet and recover. And obviously this population, like many, is having a difficult time. And that program that Director Stowe and I attended, that was the first of its kind. that was the first of its in the county's history where they brought employers formerly incarcerated. It had never happened before. You had a full room of 100 people, and so I think even considering the funding for Department of Corrections, to as a potential vehicle, not saying a separate and apart from the Human Rights Office, which also needs funding, but I just mean they're programmatic. That might be a place to tap into to build upon the kind of these type of programmatic things, but also the communications point is very important. And I personally commit, and I've started to try to do this, that I think there is philanthropy. This is an example of a public-private partnership opportunity as well, where there could be some people who care about this type of issue that would want to help with the communications effort that will be required to get this information out. So I just wanted to flag that as well. But it's an important point. I still think we should obviously pass the law, but that there's going to need to be significant work done there as well.
Okay. I see no other comments regarding this specific item, so I think without objection, we are pursuing the recommendation as it appears in the packet. Okay. Yes, Ms. Swans.
Sorry, just to clarify, so that's we're leaving it as one or more employees, so that's consistent with the rest of the human.
Correct.
Okay, thank you.
Correct, but if we could revisit Ms. Wellens, and this may require a little bit of work, Mr. Stowe, and I love your point, Councilmember Jawando, about adding the corrections component to make this a really holistic, exemplary model, and kind of take it to the next level. But I do think thinking through, Mr. Stowe, a budget that would be appropriate from a communication standpoint would be helpful.
Yes, sir.
All right, let's move on to the third point then.
Can I just check?
Yes.
Is there a penalty associated with this?
Yes, and Director Stowe might be able to speak to this better than I can, but yes, it is subject to the general enforcement provisions of the OHR laws, the Chapter 27 of the Code. So someone who believes that there has been a violation of the section would bring a complaint to OHR. OHR would investigate. They might try to conciliate. They might try to do a more informal process. They would make findings, and then the employer in this case, would have the opportunity to appeal to the commission. And then the law allows for damages to be imposed and a $5,000 civil penalty.
And the penalty goes to not to the person complaining, or who gets that up to $5,000?
Mr. President, my understanding the county does.
The county receives that. Okay.
That's my understanding.
And the person can get damages and also attorney's fees, is my understanding.
But through Office of Human OHR or Office of Human Relations, or do they have to go to court?
It's my understanding we will be able to have that be part of the actual settlement, as it were, or the adjudication of that case, Mr. President, as part of our process. And that then would go to the person, as Ms. Wellens has just stated, but it would come through our process. Now, the person always has a right then to take matters that we
appeal
for us into court themselves with proper counsel. That always is their right to do that.
I know. Thank you.
Okay, Ms. Wellens, let's move on to the third item.
Okay, thank you. The third item you've already discussed kind of in the context of the other items, but relates to the timing of the criminal records inquiry. And as you discussed, under the bill, it would occur after a conditional offer has been extended. Under the current law, it can occur at the conclusion of a first interview. There are several states and jurisdictions that follow the model of delaying the criminal records inquiry until a conditional offer has been made, including California, Hawaii, They're Austin, Texas, Baltimore, District of Columbia, Philadelphia, New York, others. And also listed in the packet, to the extent that it's, helpful to you, there's some pros and cons listed about the timing of the inquiries, pros and cons listed by council staff back in 2014 when this was initially considered.
And I could chime in just briefly. I think we discussed this a little bit already in the first discussion, as Ms. Wellens suggested, that about when you can ask. So a key function is moving it to the conditional offer. So I feel like we've gone over this a little bit, but that's what the third point is.
And if I can, I'm sorry, I hope I'm not interrupting, but I just wanted to make clear, just to make sure we were on the same page, with respect to those certain types of offenses, second degree assault and the others, first conviction of trespassing, etc. Those would never, so under this law, those offenses would never be considered. So the employer, those would be off the table in terms of what the employer considers. I just wanted to make sure that point was clear.
It is for me, but again, I wanted to dig a little bit deeper on second degree assaults. Again, prepared to move forward what was out of the committees, but just wanted to learn a little bit more about that specific issue. But I do understand that point, and I believe my colleagues do as well. But it's a point well taken. Okay, so we did discuss this and the importance of having this be after the conditional offer. I am sensitive to the cons raised in the packet of timing and the possibility of it delaying the hiring process, or an employer potentially losing an employee if you've got somebody who, for whatever reason, doesn't make it through because of that criminal record that they are able to check and do confirm that it's not something they feel comfortable with. That is a concern, but not enough of a concern to me to prevent moving forward the bill as it currently is written. Any other thoughts on that? Yes.
I agree with you. This one is, if someone has gone that far, they have met the criteria for why somebody wanted to hire them. And then if the criminal part of what they can ask about is so much of a concern, then they don't want to hire them, then that's their decision. I mean, let's face fact, you can make an offer to somebody and they say, how much are you paying? And you tell them how much you're paying. And they say, look, I can't work for that number. I need more money than that. And that they don't take the job. So that employer is back to square one anyhow.
You can build the timing into your hiring process too.
It does, but
you
still have,
yeah.
You don't have
I'm agreeing with you.
You don't have that employee until they take the job.
That's right. No, I totally agree with you. And I think in addition to that, again, there can be an adjustment of the timing of the hiring process to prevent somebody from possibly losing somebody. But I also think that's predicated on the communication component and making sure that we have people understand what this is, what it is not, and that's why that the investment, I think, is going to be really important to get this right. Councilmember Glass.
Yeah, just to that point, and my neighbors are in their yard, so I don't know if you can hear them. But before joining the council, I hired a number of people in previous professions and roles, and there are always pitfalls, right? You hire people that looked great on paper or on the internet, and whatever it might be, and then you have the interview and everything goes swimmingly, and then there was a disconnect. Maybe as the employer, you weren't told everything, right? And so I've had ups and downs in the hiring process that had nothing to do with criminal background. That's just the hiring process. And so we are not going to fix the hiring process for employers and the ups and downs that everybody goes through in hiring people to staff their business. But the goal here is to make sure that individuals who rightly deserve a second chance get their foot in the door and at least have that conversation and have that email or their online application, if that is the case, go through the initial screening. And so for anyone who I think would express concerns about a cumbersome hiring process, well, the hiring process is already cumbersome. And I think everybody would agree to that. And so the goal here is to be more fair and equitable for our residents who might have made a mistake. And so I just wanted to share that and share my personal experiences with the hiring process.
Okay, Ms. Wellens, I think those were the three main points. Were there any others from the packet that we wanted to discuss? And if not, we can summarize where we are now, and then I think there's enough information here to move this forward to council. But Ms. Wellens, anything else we haven't covered?
I think we're at the summary stage. Thank you.
Okay. So according to my notes, the first point is confirming the staff recommendation and addressing that language that talks about those misdemeanor offenses that do rise to the level of felony and providing that clarification in the bill. The second is, Mr. Stowe, a homework assignment for you and your team, informing us about a suggested number for a communications campaign with a breakdown of what that might entail and what that might look like and what it would pay for. I think is something we would like to discuss as well. And what were the other summary points that you had, Ms. Wellens?
Another point I had was to follow up in particular, and I'll certainly include in memos to everybody, the additional context and information about second-degree assault, and in conjunction with also, altering the language on that point, and then including within the bill, I think that Council President Katz, sorry, looking at my notes here, right, Council President Katz had said that we should make explicit in the bill the types of employers who are exempt from the scope.
Yep.
So I'll include that.
Good point. Okay, hearing no other thoughts or comments from my colleagues, could someone make a motion to move the bill forward with the amendments as discussed?
So moved.
And do I have a second from Councilmember Hucker? All those in favor, please raise your hands. And that carries unanimously. So, not sure, Ms. Wellens, do we know when this will be taken up at full council?
We do not, but I can certainly coordinate with the clerk's office and the council president's office as soon as possible to determine that.
Okay, and obviously, however long it takes us to get the information as a follow-up, we don't need to rush this in terms of, we want to make sure we have that information going into that full session. So,
I just want to say thank you for the thoughtful consideration, everybody. I appreciate it.
Absolutely. All right. With that, Ms. Wellens, nothing else, right? That's all we had today?
Correct.
Okay. Then I think we are adjourned. Thanks, everybody.
Thank you.